Well, thank you very much. It's equally an honor for me to be with you. I'm sure many of you know that Amnesty International cares deeply, very deeply, about the human rights situation in Sri Lanka, and has not just for years and decades. So anytime there's an opportunity to really grapple with the challenges, the very real challenges, but opportunities the country faces, it's a great chance for us to share some of our findings and recommendations. I'm only sorry that I've not been able to be with you for the rest of the day, although, of course, my colleague John Argue has been here, and I expect a rich and wonderful briefing from him. I'm going to focus on the issue of impunity, justice, and accountability. And of course, not having been here the rest of the day, I get to do so blissfully unaware of whether others have already said things that either contradict what I'm about to share with you or have already covered some of the same ground. But even if that's the case, I think these issues are so vital, so long neglected in Sri Lanka that I'm not at all reluctant to cover the ground again. You know, I think behind the rhetoric and all of the geopolitical machinations and behind the posturing at international meetings, be it at the UN or off at the Commonwealth, behind all of the legal terminology and a litany, of course, of commissions and inquiries and reviews, behind the impunity and the utter failure of accountability in Sri Lanka, behind all of that lie not just a handful or dozens, but of course legions of human stories of loss and death and fear and a hunger, a desire, a deep, deep drive for justice. Ponuthurai Yogoraja lost 2 sons in Sri Lanka in the same year, in 2006. And he has seen no justice. He's only seen deeper injustice. We featured his case in a recent report that we highlighted about this ongoing failure of justice in Sri Lanka. His youngest son, Hemachandran, was one of 5 students shot and killed by Sri Lankan security forces on that beach in Trincomalee on the 2nd of January 2006. His elder son, Kodiswaran, was killed in August of the same year, one of the 17 aid workers massacred in the town of Mutur. And in March of 2008, the father, Ponuthurai Yogoraja, testified before the Presidential Commission of Inquiry. You remember it? One of many inquiries and reviews over so many years, which was mandated to investigate, quote, serious violations of human rights. He described the frightening search for his youngest son the night he was killed and of finding his body hours later. He then described how his elder son, Kodiswaran, received threatening phone calls at work just after the death of his younger brother. As he described it, my elder son was working for Action Against Hunger, and the Special Task Force gave him many calls, and he feared for his life, and told me not to reveal anything in the courts, saying they would shoot us. 6 months later, Kodiswaran was dead. Well, Ponuthurai Yogoraja was forced into exile after the death of his 2 children, and he later testified by video conference to the commission from a location outside of Sri Lanka. And as he said at the time, in the country of my birth, I couldn't give an independent statement because I was so intimidated. My children were so afraid that I would be killed, and therefore I could not give a statement freely. I wanted to make the same statement in my country that I make here from outside of my country, but my children did not permit me to, as they were afraid for my life. 2 months after he did that, in May 2008, the Sri Lankan government ordered an end to the use of video conferencing in the Commission's hearings, a real commitment to justice and accountability. Well, at the heart of the years and decades of widespread human rights violations and armed conflict marked by massive violations of international humanitarian law, violations, of course, attributable both to Sri Lanka's security forces and the LTTE. At the heart of those relentless years of violations, a total failure of justice and accountability, poignantly captured in Ponatharai's story. Individuals responsible for all of those abuses have been spurred on, confident that a deeply entrenched culture of impunity would shield them. The pattern had become so troubling that in June 2009, Amnesty International published a report, 20 Years of Make-Believe, Sri Lanka's Commissions of Inquiry. Some of you probably know that report. And doesn't the name say it all? 20 years of make-believe. And that report did document 2 decades of commissions, panels, inquiries, reviews, all ostensibly set up to examine human rights violations, but all in the end, really, subverting human rights justice, protecting human rights criminals, and failing utterly to ensure justice or offer redress for the many, many thousands of Sri Lankans who have experienced terrible human rights violations. Since the armed conflict came to an end in 2009, Amnesty International, numerous other both Sri Lankan and international human rights groups, key UN human rights experts and bodies, a number of foreign governments, including Canada, and most importantly, the survivors and families of victims of human rights violations have all said it cannot be more make-believe. If there is no real justice this time, no meaningful accountability for the terrible abuses that happened in the final weeks of the conflict, but more widely as well, the only belief can be that there will be more abuses. Without that accountability, Sri Lanka's path forward towards stability, reconciliation, and a new culture of human rights protection is simply not attainable or sustainable. There was a promising first step. It came in May 2009, shortly after the fighting had come to an end, and while Sri Lanka was, of course, still deeply mired in a human rights crisis, marked by thousands of people being arbitrarily locked up in detention camps. And at that time, the UN Secretary General, Ban Ki-moon, visited Sri Lanka. And at the end of his visit, he and President Rajapaksa issued a joint communique. Some of you may remember it, in which the Secretary General, quote, underlined the importance of an accountability process for addressing violations of international humanitarian and human rights law. And right alongside him, President Rajapaksa promised that his government would, quote, take measures to address those grievances. Well, a year later, in May 2010, concerned about a lack of progress, the Secretary General took another step. He named a panel of international experts to advise him on accountability issues in Sri Lanka. The panel of experts, of course, submitted its report to Secretary General Ban Ki-moon in April of last year, and they concluded that they had, quote, found credible allegations which, if proven, indicate that a wide range of serious violations of international humanitarian law and international human rights law were committed both by the government of Sri Lanka and the LTTE, some of which would amount to war crimes and crimes against humanity. The report went on to recommend to the Secretary General that he, quote, immediately proceed to establish an independent international mechanism to do 3 things. First, to monitor Sri Lanka's own domestic accountability processes. Secondly, to conduct independent investigations into the allegations itself. And third, to collect and safeguard evidence. Well, 10 months later, that has not yet happened. Meanwhile, as soon as the Secretary General had set up the panel of experts in May 2010, the Sri Lanka government announced another commission, the Lessons Learned and Reconciliation Commission. And we and many others said at the time that everything about it, its composition, its mandate, its powers, its ways of working, unfortunately made it very clear that this was more of the same. more make-believe. Whatever constructive contribution it may offer with respect to reconciliation and other imperatives, the LLRC was in no way a credible and effective accountability mechanism, which is what the Secretary General and the President had ostensibly agreed to when they stood beside each other in May 2009. Nonetheless, it is, of course, what the Sri Lankan government has used repeatedly to deflect international calls for something meaningful. Well, we've been following it very closely. Amnesty International publicly, along with a number of other organizations, indicated that we would not participate in the work of the Commission. We would not appear before the Commission because we were so concerned about its fatal shortcomings. But we have certainly followed its work closely. We've reviewed transcripts of the Commission's hearings while they were underway, and our analysis certainly affirmed those fears, that there was not even a glimmer of a commitment to the notion of accountability in the work of the Commission. In early September, we had seen and heard enough. We issued a major report, When Will They Get Justice?, outlining our concerns and stressing that the failure of the LLRC to deliver justice was clear and underscored why it was so critical to go back to what the panel of experts had called for and establish that international mechanism. That assessment was only confirmed when the LLRC report was made public in mid-December. The report acknowledges serious human rights problems in Sri Lanka, but falls far short of addressing the war crimes and crimes against humanity committed during the final phases of the conflict. It ignores serious evidence of war crimes, crimes against humanity, and other violations of the laws of war by government forces, even though the report highlights the serious and systematic violations committed by the LTTE. In our view, it reflects the bias that was evident in its composition and working methods. It does offer some interesting recommendations about how to improve the overall human rights situation in the country, and we've certainly urged that the government needs to take those recommendations seriously. For instance, the Commission received numerous testimonies about enforced disappearances, illegal or abusive detention, and extrajudicial executions going back quite some time. And they called on the Sri Lankan government to investigate those reports and prosecute violators. And importantly, the report notes that many people stressed that, quote, definitive action against alleged cases of disappearances, as well as preventive measures, would have a significant impact on the reconciliation process. But the report's major shortcoming lies in addressing alleged violations of the laws of war, where the LLRC appears to have taken the government's responses uncritically. They admit what the government of Sri Lanka has assiduously denied, that civilians, including those in hospitals, suffered directly as a result of LTTE and government shelling. But the LLRC's blanket rejection of government targeting of civilians and its deliberate downplaying of the numbers of civilians caught in the final phase of the conflict is simply not warranted or substantiated by the evidence, including the evidence that was presented to the LLRC. Well, unfortunately, the Sri Lankan government has mounted and continues to mount what I think it would be safe to describe as an aggressive campaign to counter all international efforts to follow up on the important recommendations from the UN panel of experts or the many concerns about the significant shortcomings of the LLRC, and has at every turn rejected the calls for an international inquiry or investigation to be established. All those who speak out about justice and accountability, who criticize the LLRC, who promote the recommendations of the panel of experts, are simply dismissed as being suckers for LTTE propaganda and being against the Sri Lankan people. I know, I've received those emails. But nothing could be further from the truth. So what are the options for Canadian foreign policy, faced with what can only be described as belligerent intransigence from the Sri Lankan government when it comes to this issue of justice and accountability? Well, Canada, I'm sure as all of you know, has in recent months taken a welcome and strong position on the issue. Very much welcomed by Amnesty International. And it's played out in two key multilateral settings, the UN Human Rights Council and the Commonwealth. Both should continue, and has also played out bilaterally in our one-on-one relationship with Sri Lanka. At the Commonwealth, Canada has made it clear that without significant human rights progress, including improvements when it comes to accountability, Canada is actually likely to stay home from the 2013 CHRV, the Commonwealth Heads of Government meeting, which is presently set to be hosted by Sri Lanka. Amnesty International has also highlighted how inappropriate it is for Sri Lanka to be the 2013 host without substantial progress on human rights and accountability. The other very crucial forum, and this is where I want to spend the remainder of my time, is the UN Human Rights Council. It was, after all, the UN Secretary General who issued the communique jointly with President Rajapaksa in 2009 and then established the panel of experts. That panel of experts, yes, independent, but working under UN auspices, was clear in recommending an international process. The UN, and particularly the UN's main human rights body, must therefore now take that up and move it forward. Amnesty International called on states to do so, to take up the issue of accountability in Sri Lanka at last year's September session of the UN Human Rights Council. And there was considerable reluctance from many corners, much of it stemming from fear that the Sri Lankan government would muster an aggressive counterattack and be able to rally many other governments to its side. And of course, many remembered the outcome of the special session of the UN Human Rights Council held in May 2009, which should have been such an opportunity to highlight and grapple with the country's ongoing human rights challenges, including with respect to accountability. But I see a few nodding heads. I'm sure many remember that instead, it became a moment really simply for congratulating Sri Lanka for winning the war. And it was by a vote of 29 in favor, 12 against, and 6 abstaining. Canada did vote against the resolution. We very much welcomed a short-lived effort by Canada, therefore, to get the issue of accountability in Sri Lanka before the Council at the September 2011 session. A proposed resolution was circulated. It was mild and indirect, but in our view, was effective and was a constructive first step forward, a way of getting the issue onto the Council's agenda as a beginning. The resolution would have essentially agreed to convene a discussion at the next session of the Council. Imagine you have to have a resolution about setting up a later discussion, but thus is the pace of things sometimes within the Human Rights Council. And that next session of the Human Rights Council is in fact now just around the corner. It's the session coming up in March of 2012. It would have focused on the outcomes of the LLRC and would have involved an interactive dialogue, a back and forth, a conversation, questions and answers between the Sri Lankan government and other governments, both members of the Council and observer governments. But even that, the Sri Lankan government forcefully opposed. And in the end, Canada chose to withdraw the resolution and to focus on the opportunities of last fall's CHRV in Australia and some other diplomacy. But now, ironically, here we are in February, and that March session of the Human Rights Council, that session that might have been, is nearly upon us. Since the September resolution never went through, there is no interactive dialogue with Sri Lanka about the LLRC or justice and accountability on the agenda. But with the LLRC report now out, and with Sri Lanka's continuing defiant stance and refusal to engage constructively with the international community about these concerns. This time, there simply must be Human Rights Council action. And Canada is well placed to lead that effort, returning to the initial foray in September and building on the strong position taken at the time of the 2011 CHOGM. Now, our understanding is that options for what action to take at the Human Rights Council and or in other settings are still being reviewed and considered by Minister Baird's office. And of course, action on various fronts within any number of UN bodies and processes, at the Commonwealth, bilaterally, and other possibilities would all be very welcome. But I do want to end by stressing how absolutely crucial it is that something meaningful and official on the agenda of the Council go forward in March, for a number of reasons. It is the UN's preeminent political body dealing with human rights issues. It can no longer be silent on such a serious concern. The deep disappointment of the special session on Sri Lanka back in 2009 still lingers. I suppose here the argument is it's time to make amends. The tentative resolution, floated then withdrawn by Canada in September, has in a way set the bar, and a failure to come back to it when there's no reason not to come back to it. In other words, the concerns, of course, were by no means resolved, and if anything, have only deepened now that the LLRC report is out and the concerns behind the resolution therefore so clearly validated. Given all of that, a failure to come back and move that forward again would, I think, be seen by many, and certainly in Colombo, as a victory by and for the Sri Lankan government. And then, of course, it was an expert panel convened by the UN Secretary General, operating under UN auspices, that has called for international action to confront impunity in Sri Lanka. So if the Human Rights Council now ducks the issue, where does the UN's voice lie? So that's why we need something at the Council in March. Why Canada? Well, I think we have already named and framed the issue powerfully and can't, therefore, and shouldn't back down unless the concerns are resolved, which they most certainly are not. We, of course, do have strong connections to Sri Lanka, not the least of which being our large expatriate community. And we have a strong, well-earned, over many years, international reputation with respect to the very issues at stake here: impunity, justice, accountability. We are, after all, the country that led the campaign to establish the International Criminal Court. So all of that makes us the obvious leader here. We were willing to be that leader in September. We certainly hope that we will be willing to be that leader again in March. So as I wrap up, one cannot end without thinking again of Ponuthura Yogaraja, who lost his 2 sons to human rights violations in Sri Lanka, and who, when interviewed by Amnesty International, had certainly, clearly, sorrowfully, but understandably come to feel that he will not see justice for those terrible crimes. So looking back to his obvious right to justice for what he has suffered, and I know there will be many here in the room who have their own memories and cries for justice, but also looking ahead to the need to build a brighter future, a sustainable future of justice and rights in Sri Lanka. What is inescapable to either looking back or looking ahead is that there must be action to address impunity, and that the international community absolutely has to be centrally involved. The upcoming session of the Human Rights Council offers the next critical step forward towards that goal, and I'd urge all of us to do what we can to make that happen. Thank you.